everybody, hot topic time in estate planning and probate. Our question today from the Lorie Burch mailbag is from Lisa Marie in Plano, Texas, and she writes, Dear Lorie, I recently got a new job, congratulations, and while filling out the beneficiary information with the HR department, they suggested that I not list my minor child as a beneficiary on my life insurance. When I asked about other options, they recommended that I speak to an attorney. I love your HR department. Can you explain what they mean and what planning I should consider if I want my life insurance to go to my children? I truly appreciate the very helpful advice you provide in other Hot Topics videos. Why, thank you, which you can view other Hot Topic videos on my YouTube page, so definitely go visit that. So this is something I am very personally passionate about, because when it comes to beneficiary designations on life insurance, retirement, sometimes your investment portfolios, though when you assign a beneficiary, it functions independently of what your will says. So if I have a will that says I give everything to Stuart, but I have life insurance that's payable to Matthew, if I pass away, life insurance is going to go to Matthew, everything else will go to Stuart. So when you have a minor child, they cannot inherit money or property outright if they're under the age of 18. So when we're talking about a will, usually what parents will say is, well, if they're underage, then I would like it to go into a trust for them. This is who I would want to be the trustee, and these are the age or ages at which I would want the trust to end and for my child to control it, which hardly ever is 18. It's usually much older. But then you go to your HR department or your insurance person and you want to put just the child's name. The reason why your HR department is sharp is because they actually told you that's not a good idea, because what would happen is that there would have to be a court involvement, a judge would have to appoint basically to oversee it, and then it usually would go into the court registry to get handed to the child, and this is really important, at age 18. So what can you do? Well, you should get a will. And then you should make sure that you're with a qualified estate planning attorney that will help you change the beneficiary so that it will actually go into the trust in the will and actually connect those dots of those things that are separate. So it's very important to make sure that you're working with the right kind of attorney that will help guide you in that process, because a lot of the clients that I have, that's where most of their money really is. Life insurance, retirement, and their investment accounts. That's the most liquid property. Sometimes I get asked, well, why can't I just name whoever I want to take care of them, my mom, my sister, or whomever? Well, you can do that. The problem is, one, you want to make sure that you can trust them to actually use it for your child. I'm going to assume that you do. But two, what happens, because it's all theirs, what happens when mom passes away? Are you going to be able to make sure that that money that you gave to her is going to be used for the kids? Secondly, when it's in a trust, it is exempt from creditors' claims, and if the child for some reason has to file bankruptcy or what have you, it is exempt. But what if your person, your mother for example, if you used her, has a lawsuit or gets sued or has to file bankruptcy? It's a personal asset that can be taken away. So just not a good idea to do that. You really do want to have a nice solid trust put in place. It can be created through the will, and make sure that the beneficiaries are then lined up to funnel that way. So Lisa Marie, you're working for a great company. Good news getting the job. And I already told you, if you want to see other hot topics, please visit our YouTube page, and don't forget to like us on Facebook. Until next time, remember, if you don't have a will, state of Texas has one for you.